This is the fall of 2004. So we've got a charge, conspiracy. It's, our view is it doesn't state a violation of the laws of war. A military commission is a body whose sole jurisdiction is to enforce the laws of war. And there's been this, essentially this new crime defined by the executive branch, despite the fact that Article 1 of the Constitution gives the power to define and punish violations against the laws of nations to Congress. Okay, so charge doesn't violate the laws of war in our opinion. Then the Combatant Status Review Tribunal finding, no counsel was present at this CSRT down in Guantanamo under the Defense Department rules. The government, in its reply brief, informs the court that there's been this CSRT, and that, by the way, there's been a finding by this CSRT that Hamdan, is an enemy combatant and he's affiliated with Al-Qaeda, whatever that means. We're not allowed to see that evidence. None of that evidence is presented to the court. There's just an oral representation, at oral argument by the government lawyer concerning that finding and a reference to it with nothing to support it in the final reply brief just before oral argument. Literally the business day, the last business day before oral argument, the government files a notice of change of circumstances, which just says, hey, Your Honor, we've taken him out of solitary confinement. And again, they lead off in oral argument by saying, all right, he's been charged, there's been this finding of combatancy and affiliation with Al-Qaeda, and he's no longer in solitary confinement. And that's just an illustration of the various ways in which facts on the ground were changing by the government at every step of the way to try to moot arguments that we were making and had brought to the attention of the court in our initial petition. And it continued throughout the course of the case. The two most singular examples, I suppose, are that they changed the rules, the commission rules that we were protesting against on the 836 argument that Charles described. 836 saying that commission rules can't be contrary or inconsistent with the UCMJ. Well, one of them was that it didn't guarantee his right to confront witnesses and adverse testimony. In August of 2005, right after we filed our cert petition to the Supreme Court, the Department of Defense changed the commission rules. It was mostly a semantic change, but they made an argument to the Supreme Court in opposition to our cert petition, saying, oh, we've changed the rules so that now he can't be excluded from trial if that would compromise a full and fair trial. I mean, what does that mean? In any event, they packaged it as a substantive change to the Supreme Court, but actually the plurality opinion of the Supreme Court noted it as an example of the kind of arbitrariness of the whole process. The rules are being changed in midstream. It's further evidence that this isn't a regularly constituted court. They also did this on the eve of oral argument before the Supreme Court in March of 2006, where they made a press statement saying, there's been new guidance issued by the Department of Defense with respect to evidence extracted by torture. If there is such, we're not torturing, but if we do have evidence that's been extracted by torture, then it's incumbent upon the prosecutors to bring that to the attention of the military commission, again, so that it wouldn't compromise a full and fair trial. But these sorts of statements are last-minute statements, right? It's remarkable how coincidental they are right before oral argument to the Supreme Court, or right before a brief is due in opposition to our cert petition, or right before oral argument to the district court. So they were happening all the time. The final act, so to speak, the heavy artillery was rolled out in December of 2005, where the administration's allies on Capitol Hill managed to pass the Detainee Treatment Act of 2005. This is after cert had been granted by the United States Supreme Court on our case. They passed legislation that purported to strip the Supreme Court of jurisdiction over the Hamdan v. Rumsfeld case. And that was immediately filed then by a motion to dismiss. We had just completed our merits briefing to the Supreme Court in the first week of January, and I think 2 days later, the government files a motion to dismiss for lack of jurisdiction based on the jurisdictional strip that is set out in the Detainee Treatment Act of 2005. We immediately then had to brief, had to develop arguments as to why that law didn't apply to already pending cases like ours, and if it did, it was unconstitutional. It was a suspension of the writ of habeas corpus. It was, it was an improper encroachment by Congress on the constitutional jurisdiction of the third branch of government, of the judiciary. Now, we'll come back. Well, let me come to the next slide.
Just one thing. In addition to all of this, at every point of the arguments, the government was saying the courts should abstain from deciding these issues now. So in addition to all this, we're being fought in the courts, saying that we have no place at this point. Let the military tribunal run its course, and then come back to this.